The left hates the First Amendment. They hate the Constitution. And they're obsessed with destroying anyone who speaks outside their lanes or their lines that they've made up. Judicial Watch filed another important federal civil rights lawsuit on behalf of a conservative teacher or educator who was fired by a school district over straightforward social media posts on matters of public concern. And the way they went about it was really nasty. We filed the lawsuit against Barnstable Public Schools up in Massachusetts. I think it's our third lawsuit up there recently over trying to protect the First Amendment rights of teachers. They really hate conservatives up there, it looks like, and have contempt for the First Amendment. We filed the lawsuit under the civil rights statute called under 42 U.S.C. 1983. It's a breach of contract case. It's a promissory estoppel case filed on behalf of John Bergonzi. And I want to go over the lawsuit with you because I think it's interesting, and I want to kind of show you how our expert lawyers, in this case Michael Pikesha, kind of develop the case and explain it to the court. Okay, statement of facts. Let's go and bring up the case. I'll bring it up so you can read it along in part with me. In August 2024, plaintiff, our client, was a tenured science teacher at Brockton Public Schools in Brockton, Mass. Plaintiff had taught at Brockton for 17 years, and he was teaching science as he had in prior years in 2024. He applied for the job as associate principal position as associate principal at Barnstable High School in August of 2024. On September 3rd, he interviewed for the associate principal position at Barnstable High School with at least 8 and as many as 13 Barnstable public school teachers and administrators. I mean, if that's not an indictment of our public school system, I don't know what is. He's trying to get a job as assistant principal, more or less, and he has to interview with 20 people. He also interviewed with the Barnstable Public School Superintendent, Sarah Hearn, and the high school principal, obviously, on September 6th. So he had 2 interviews. During the interview process, this is important now, Barnstable Public Schools personnel clearly and unambiguously told him multiple times that, here it is, let's look at this on screen, that no employment offer would be extended unless and until the district reviewed his social media activity, including its Facebook page, for any issues or concerns. It was explained to the plaintiff that a social media check was a routine part of the district's interview process. So they warned him, if we find something on your page we don't like, you may not get the job. And I think that may be their right, I'm not sure. So we'll see as we argue the case how that plays out. At no point during the interview process did any personnel apprise him of any issues or concerns the district had about his social media activity, including his Facebook page. So he got the job on September 10th. He accepted the job orally, so the superintendent called and offered him the job. He accepted it. And then he was also told at the time, well, now you got to go through the paperwork. He met with the human resources personnel folks for the public schools at Barnstable on September 24th to begin the onboarding process. That's the HR term for getting people situated in an office or a new job. You have them fill out the forms, you describe policies to them, give them some information about their job now. So he completed the onboarding process on September 30th, 2024. It took a week. At no point during the onboarding process did any Barnstable Public School Human Resources personnel raise any issues or concerns about his social media activity. And he was told his start date would be October 7th. He got his start date. This is key. After completing the onboarding process on September 30th, 2024, and receiving his start date, The plaintiff resigned from his tenured position at Brockton Public Schools in reliance on Barnstable Public Schools' promise of employment and representation about performing a social media check. So he had a tenured position, nearly 20 years as a teacher over at Brockton. They said, you've got the job, we're going to hire you. We might do a social media check, but we'll let you know if there are any issues. They offered him a job, he took it, went through the onboarding process, got a start date, he quit his tenured position. No one told him there were any issues with his social media. So you can guess what happened next. He began working on October 7th as previously agreed. He got a letter confirming his start date, what his salary was going to be. Your start date, and this is what they said in the letter, your start date is determined by a successful background check. So they said, you got the job because you passed the background check. The representation further confirmed that he satisfied all requirements for employment. This is what we allege, including passing a social media check. On November 20th, he gets called into a meeting with the union, the public schools human resources director, and the principal. He's handed a letter signed by Superintendent Ahern, placing him on paid administrative leave effective immediately pending an investigation and allegations that there were memes and posts on his Facebook page that required investigation. And these Facebook page memes and posts were not buried. They were all recent, upwards, from 2022 to 2024. So it wasn't like they had to, we didn't go back far enough. No, they were up in front. And by the way, he was promised that it would all be done, and the reason he got the job was because they had looked at this sort of stuff. But no. He subsequently learned that the investigation originated from an email sent to Barnstable Public Schools on November 15th, 2024, by an individual identified only as a concerned colleague. So later, in December, he was in a meeting. He had a meeting with the assistant superintendent in this case, and the human resources director, and they showed him the following Facebook posts. Can we bring that up here? So these are some of the posts. Some of it uses some, he says the word a-hole. Basically anti-immigration posts, complaining about Boston mayor engaging in racial separatism. I mean, look at this. This is what bothered them. If a fence around the Capitol seems like a good idea, but not on the U.S. border, you're a special kind of stupid. Come on. What's the big deal about any of that? And plus, it's free speech. Even if you don't like it, tough. So all of this was public before he applied. And they promised him a job based on a review of such posts. And then he quit another job, took this one, and then they pulled the rug out from under him. No one complained other than this person. So there was no disruption or crisis at the school as a result. This is just, in my view, we don't say this in the lawsuit, so this is my interpretation of it, a bunch of left-wing activists working in the school system up in Barnstable, going after this poor guy, our client, for having the wrong views and retaliating and firing him. And you can't do that under our laws. So this is retaliation under protected speech. So this is the 42 U.S.C. 1983 claim that we filed. At all relevant times, he was engaged in constitutionally protected speech when he posted content on Facebook that addressed matters of public concern. Defendant, acting under color of Massachusetts law, deprived plaintiff of his rights under the First Amendment by firing plaintiff for engaging in protected speech. It was the breach of the contract. So, you know, he had this essentially hiring contract. It was a breach. There were some, you know, even as an at-will employee, even as an at-will employee, you can't get fired for retaliation like this. It's not right. And then count 3 is promissory estoppel. Now, as a lawyer, I always pause when I read that, but what I love about that phrase, it kind of vaguely explains, even if you don't know what it means, the words themselves kind of explain what the issue is. Promissory. The key word there is promissory, is promise, right? Essentially, he was promised the job, he relied on that promise, and they pulled the rug out from under him. We got this job. By the way, the only way you're going to get it is if you pass our review of your social media. They told him he passed the review because they offered him the job, gave him other information saying he passed the review. He quit his other job to take it, began working, and then a few weeks later, because some activists contacted them, they fired him. So, you know I normally don't go through lawsuits like that, but I think it's very interesting to see the process that plays out in the lawsuit itself. And to me, it's devastating what happened in terms of the legal liability that is clear cut that these people face up in Barnstable for firing our poor client. And so this is the sort of work that we've been specializing in recently. Because the rules are, if you're a conservative who's a teacher and you say something outside the classroom that has no impact on the classroom. So it isn't like our clients are going to class and saying, you know, the ICE agents are the Gestapo, which is what the left does all the time, right? But they're not saying controversial things in class. These are statements that take place, in this case, long before he was hired. Few years in part, some of these are a few years before he was hired, or you know when people are on vacation, or just just basically making comments in their personal capacities. And public schools are government entities, and they can't fire people in retaliation for their speech. Punish their speech in this regard. They're not disrupting the school. They're not saying things at school that are inappropriate. It's they don't like their speech outside of school. So if the first, there are 22 million public employees, which don't get me started how outrageous a number that is. The point is, you can't have all of those public employees have their First Amendment rights suppressed as a condition of employment in an inappropriate way. Because you obviously don't have absolute First Amendment rights, free speech rights in the conduct of your employment sometimes. Like I said, you can't go into a classroom and start saying crazy things one way or the other. So this is the challenge we're facing. The left hates the First Amendment. They hate the Constitution, and they're obsessed with destroying anyone who speaks outside their lanes or their lines that they've made up. And we're going to court to try to vindicate the rule of law. We got requested a Supreme Court on behalf of another teacher who was fired for posts she made opposing rioting while she's sitting on the beach. I mean, this is how crazed the speech police are. And we're not supposed to have speech police in our country. That's what our Constitution's about, is to prohibit that type of abusive activity. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.